The Waqf Amendment Bill is challenged in the Supreme Court, and these are the 5 takeaways from the hearing in the Supreme Court. Takeaway number 1 is to do with Waqf by user, and let me explain to our viewers what it refers to. It refers to a property that is treated as Waqf based on long-term usage for religious or charitable purpose, but without formal documentation. Now, this argument was raised by the center that owing to non-availability of documents, certain properties declared as Waqf by user should be null and void. But the court does not agree. The court says, how can you simply cite non-availability of documents as the reason for disallowing Waqf by user? That's takeaway number 1. Takeaway number 2, the court also says the legislature cannot declare a judgment, an order, or a decree as void. That is not up to the parliament to do so, or the legislature to do so. You can only take the basis. So clearly the Supreme Court has taken a strong position on this, that the legislature, the government of the day, the parliament can only do so much and not beyond that. Takeaway number 3, the court says it's a genuine concern that there is a misuse of the Waqf by user clause. In fact, it cites the fact that the Delhi High Court is built on Waqf land. So it clarifies that we are not saying all Waqf by user is wrong, but yes, there are certain genuine concerns. Takeaway number 4, Solicitor General Tushar Mehta had said that a large number of Muslims do not want to be governed by Waqf Act. To this, the response was, are you saying that from now on you will allow Muslims to be part of Hindu endowment boards? Say it openly. So the court is very clear that you cannot simply come up with this argument that the Muslims themselves do not want to be governed by Waqf Act. The court, in fact, added to this saying that a public trust that was declared as a Waqf 100 or 200 years ago cannot suddenly be reversed because you cannot rewrite the past. The other big takeaway here, the final one, is that the Supreme Court has expressed its disappointment over the repeated violence over this issue. The court said, and I quote, one thing that is very disturbing is the violence which is taking place once the matter is before court. That should not happen. So reassuring the public at large, the communities at large, that rest assured the court is looking into it. Where is the need for any violence or dispute in this regard in the public space?